welcome to Arbitral Insights, a podcast series brought to you by our international arbitration practice lawyers here at Reed Smith. I'm Peter Roscher, Global Head of Reed Smith's International Arbitration Practice. I hope you enjoy the industry commentary, insights and anecdotes we share with you in the course of this series, wherever in the world you are. If you have any questions about any of the topics discussed, please do contact our speakers. And with that, let's get started.
Hello everyone, and welcome back to our latest episode of our Arbitral Insights podcast series. And I'm delighted today to welcome Rachel Ansell QC of 4 Pump Court. Hello, Rachel.
Hello.
Rachel is a very prominent QC. She's at 4 Pump Court. She took Silk in 2014 and has a market-leading practice in several areas, including insurance, energy, construction, and international arbitration. We will be focusing on her international arbitration work today, but amongst other things, one of her most prominent cases was the recent business interruption insurance case, which many of our listeners will be aware of, which was the Financial Conduct Authority and Arch Insurance UK and others, which went all the way to the Supreme Court. Rachel has several accolades to her name, and I cannot resist mentioning at least a few of them. She was awarded the International Arbitration QC of the Year at the Chambers UK Bar Awards in 2019, and in 2017 at the same awards won the Construction QC of the Year award. Amongst several of the wonderful comments that have been made about her practice over the last few years, it's hard to pick out a few, but I just had to pick out at least the following 3. She's a ferocious and incredibly effective cross-examiner. She is a litigator's dream barrister, and she is one of the new breed of barristers. So with that said, Rachel, a very warm welcome again, and I'm delighted to be speaking with you today.
Well, thank you very much, I think.
I think you'll be absolutely fine. Just how stellar you are, you will be absolutely fine. Now, one of the things I always ask our guests in this series is what brought them to law. So, Rachel, why did you choose law in the first place?
Okay, so I'm going to go back in time to when I was a student studying my A-levels, and I'd chosen biology, chemistry, maths, and English, with the whole idea I was going to drop one as I went along. I didn't. I kept all 4. But I decided I didn't want to be a doctor or a scientist. But equally, I didn't think that I wanted to do an English degree. I wanted something I thought that was more analytical, and given my parents' sort of financial circumstances, a vocational degree felt like a more sensible option for me. So I arranged some work experience with a local solicitor and was absolutely sold and thought, that's it, I'm going to do law. And I must also be honest, because I was asked that question by who then became my director of studies during my interview at Downing. And I'd answered the questions very much along the lines that I'd said, but then I was very honest with him, and I said, and also I do actually want to make some money when I work, and I think law will give me that opportunity.
Always best to be honest.
Yes, exactly. Well, it didn't put him off, so he made me an offer.
Wow, wonderful. And then when did you get the desire to become a barrister, right? Because you mentioned you did some experience in a law firm. What sort of brought you onto the barrister side of the profession?
Well, within about 2 weeks of joining Downing, we had an early mooting competition, which I was lucky enough to win with my partner. And at that point, John Hopkins, who was my director of studies, says, Rachel, I think you're going to be best made for the bar. You've obviously liked the advocacy, you're good at it. And he also thought that I might be a little bit too stubborn, I think were the words he used, perhaps to be in a solicitor's office and being told what I was doing those early days without having my own autonomy. So it was very much him. And then he arranged, or I went on quite a lot of mini pupilages to make sure, because it was very daunting, because there were no lawyers in my family. And the bar seemed like a frightening career choice at that time, because it did have no security. It wasn't that you were going to get your starter's salary or anything else. It was a small pupillage award, although I was lucky I did get a generous one. But it was very much with his encouragement.
Wow. Yeah. Well, that leads very nicely into the next segment, Rachel, which is about those people who've mentored and sponsored you in the course of your career. You've already referred to one,
Yeah.
but I wonder if you could share this with us, because it's always something where, as we get more senior, we look back and we realize how much we've benefited from our mentors and sponsors.
Yeah. So I'm going to start again a little bit further back, which is actually with my parents, who said to me and my sister, they had two daughters, you're going to have to be twice as good as any man at what you do. And that's incredibly unfair. But luckily, you have the skills to do it. And you've just got to work hard
Mhm.
and get there. So they were a great support. And they really believed when I said, I'm going to go to university, no one had gone to university in the family. So then I thought, I'm going to apply to Cambridge. Rather than saying, what are you doing? They were very encouraging. I will obviously mention John Hopkins at Downing. His wife was also a tutor, Cherry Hopkins. And between them, they really looked after me at university. And I turned up all proud with my English A level, which I'd got a grade A in, which was the highest grade in those days. And I turned up very proud and I produced my first essay in Roman law. And John Hopkins put a line through it, then ripped it up. And he said, I've got no idea what the content is, but you may have an English A level, but your grammar's appalling. Now, I come
Mm.
from a state school. I don't remember particularly having a grammar lesson. And John and Cherry spent a lot of time just teaching me how to write. No criticism of my intellectual ability and very encouraging on that. But so in terms of mentoring, that was really helpful because you can imagine at the time when you're training, you think, oh, your advocacy is actually going to be on your feet. It's not. So much is the written word. And they gave me such a brilliant, but it was the encouragement and the belief in me. And so those two. And then since I've been at the bar, in terms of at Chambers, David Friedman QC, who was head of Chambers, took me under his wing from a very early age and was always very encouraging, but properly critical when he needed to be. From other chambers, Chantal Doriez QC, who's now head of Chambers at Atkins. So she probably would hate me saying she was a mentor because she'll say that makes her feel old. But there is sort of 5 or 6 years between us. And when I joined Chambers, there weren't any really female construction lawyers in Chambers. So it was brilliant having a mentor of that type and now a friend. The same with Mrs. Justice Neris Jefford also. And then going back even a little bit further, though, is Lady Justice Carr, who everyone I'm sure will know. I did a mini pupillage with Sue right before I'd even got called to the bar. And I thought then that she was a phenomenal woman. She was encouraging then, and she has remained encouraging ever since I first met her back in 1993. So they're the main mentors. I'm sure I've missed people, to which I apologise, but they're the ones that come to mind.
Well, that's a formidable list, Rachel, and that's a lot of superb people who've
Yes.
given you support and advice along the way. And one thing before I ask my next question, I will tell you I had a very similar experience when I was a very young lawyer, when I was a trainee solicitor in those days, an article clerk, learning the importance of precision in drafting. Because it's one of those things, as you rightly say, a lot of people think advocacy is about the oral advocacy. Of course, it's very important, but written advocacy is really the dominant form of advocacy. And I learned that very early on in my career too. So with what you've just said, it really resonated because people read more of what you produce than what you say.
That's for sure.
And, a lot can be done on the papers before they've even heard you speak. So, no, thank you for sharing those very wise words. So, in terms of all the experiences you've mentioned about all those positivities that you got from your mentors and your sponsors, how has that process shaped how you now mentor young and up and coming barristers and other lawyers?
Well, I hope always that I keep the enthusiasm for the job and trying to say, however bad it feels at 11 o'clock at night when the other side have just dumped 3 killer documents on you, which they've just suddenly found in the loft of one of their witnesses' homes. However bad that feels, there'll be an up point, and stay enthusiastic about it. I love my job and I really enjoy it. And you've got to stay enthusiastic. And I think that's really important. We all have downtime. And that as a mentor, I think is a really important thing. You're working your 5th weekend on a row because you're in a long hearing, but there's still up points. So enthusiasm, I think, is very important. Having time, always making time, even if it's just a coffee. We all need a break at some time. And so rather than trying to say, I'll have 5 minutes this afternoon, take the time to sit down, because it's better to have quality time. Always be honest as well. So sometimes one of your mentees might come to you and say, it's outrageous, this leader's just asked me to do that, or this leader, she's just criticized me for that. At times that criticism may well be well placed or maybe correct. And I think you have to be honest. There's no point telling your mentees they're doing everything well if they're not. And that goes back to John Hopkins ripping up my first essay. Sometimes you have to be cruel to be kind, but then also listen, because you can learn as much from your mentees as they can learn from you as a mentor. And that's especially true, and I'm sure you find this when you're leading teams. You've got to listen to the team to get the best out of the team. So mentoring works well, and especially as self-insured barristers, we're never taught to manage people. All we can do is learn from the people who we've been managed by, to varying degrees of success and styles. So I think that's what I've learned, is to see it as a two-way process, but also to take it seriously, because without what others did for me, I wouldn't be where I am now.
Thank you. And it's so true. And the point you made there that, again, resonates with me is about the importance of learning from each other and listening to each other. I still recall the times when the bar was very different to what it is now. And consultations or conferences would invariably take place at the barrister's office. It would be one of those things where it would be very sort of ceremonial, quite magisterial in form. But actually, it's great now how we can all learn from each other. And certainly a lot of people I've learned the most from are younger than me, are more junior than me, not just more senior to me or at peer level. I agree with you completely on that. One of the focuses of this series is international arbitration. That's obviously an area where you, Rachel, have a lot of experience, and it's a core part of your practice. I mean, one of the things I always find fascinating is to ask guests how they first came into the world of international arbitration. Is it something you sort of stumbled upon, or was there a case that you did that then sort of set the ball rolling? Did one of your colleagues bring you into a case? Just tell us a little bit about how the genesis of your arbitration practice came to be.
So I was on the committee of Tech Bar as a very junior member. And the DTI and the Ministry of Justice approached Tech Bar to send out a delegation effectively to the Middle East to promote the English sort of arbitration bar and arbitrators, and in return to offer, we hope, sort of some legal services, sort of reciprocal with training and the sort, because you've got to remember this is back in sort of 1990 or maybe just in the early 2000s, but a long time ago. So I went out on this delegation feeling a bit like a fish out of water, because there were some very senior QCs on that trip, and there was me, barely out of nappies, to use the colloquial. And while I was out there, I met a few solicitors who had been referred to me by solicitors back in London. And as a result of that, I got my first DIAC arbitration, which I did. And actually it was quite familiar, because John Marin QC was the arbitrator, so it didn't feel completely. And so I did that arbitration and sort of never looked back, really. And what's been great, and I think mainly, perhaps this picks up on the point we were talking about before, about working in teams. I think that's particularly true in the International Arbitration Forum, because what I love about international arbitration is getting to learn the different systems, because sometimes you'll feel like you're in a civil system as opposed to a common law, and the different laws and the different way people work. And so to me, that's what I love about arbitrations. And you have a little bit more freedom with you don't have to be quite so technical in your pleadings. You can perhaps make some of those points and use the flowery language you wouldn't always be allowed to, or would be appropriate in court, obviously within reason. But I like having both. But that's how it started way back then, after a delegation to the Middle East.
Yeah, and a trip to the Middle East, did that really sort of spawn the construction side of your practice too? Because the Middle East has been the source of a lot of construction disputes over the years.
I think that's right. I was already doing construction, but very domestic based. But yes, you're right. And it sort of exploded in Dubai. And then obviously it sort of reduced. And it's actually now in a much greater, wider region of the Middle East now than just Dubai. But yes, that certainly fueled my construction practice, and which I really enjoyed. And obviously it's very good. I mean, I like the construction work because of all the different sort of technical side of it, which takes me back to my science A levels, and really getting into the nuts and bolts about the geotechnical engineering, for example, which is obviously quite interesting in that region where different places have different sort of earthquake zones and things. So, yeah.
No, I could talk to you a lot about this, but I don't want to deviate on, our discussion. But yeah, I've been involved in some fascinating construction-related cases in the past, and I always find the concepts in them. You learn so much, actually, that you just didn't know before. It's just one of these things you just keep learning on these things. No case is ever the same, and that's a cliche, but it's very true in construction. So arbitration is now, as you know, Rachel, it is the dispute resolution mechanism for international disputes and in a range of areas. But it's not perfect in terms of how it operates. And I think all of us who are involved in it would accept that. Are there any particular facets of international arbitration as a process which you think could be improved to make it better, not least for the consumers of arbitration?
I think what I've been finding more recently is that there are obviously arbitrators who are incredibly popular, and we all know how difficult it is to organise diaries, and we all have to do that. But I think what's important about arbitration is it retains flexibility, because the parties, it's not only confidentiality, it's having control over your process. As you say, these are the consumers. Your client wants some control. Now, with all the will in the world, you start proceedings or you're defending proceedings and things change as you go along, which might require a change to the timetable. And it's no one's fault. But whereas we all know getting extra time or whatever in court can be very difficult, what I'm finding it's actually even more difficult sometimes in front of tribunals, because the tribunals members will say, well, if we move the date now, you're not getting a hearing for 2 years. Well, that's
Absolutely.
unsatisfactory, because that has the result that actually no one comes out of that very well. Neither of the parties are going to be happy, because neither of them are getting the chance to put their case properly. If you're the party who needs more time, you feel unfairly done by. So I think that's a real issue. I don't know how we make it better, because obviously everyone wants their arbitrator of choice, but that's something that concerns me. So I don't like that. Equally, I don't like tribunals who think, well, actually, we're not court, so you can have whatever time extension you want. So then you find you're also sort of waiting for then 2 years for any decision. So I don't know how one does that, but I think that's something that, I don't know, maybe one could encourage tribunals to perhaps have more, maybe call it, award writing weeks or something. So, and sometimes you don't always feel that tribunals have had enough time between hearings that they might not have read in, which is quite difficult, again, if you've only got a week hearing. You really need your tribunal up to speed. I mean, I'm sure they would then say, well, Miss Ansell, what you need to do is do a better written oral opening and written opening, and we'll understand it. But that's, I think also length of time for awards is something that we probably need to improve, because I think that does frustrate clients when they have to wait and wait and wait. And actually, as an advocate, can frustrate you because you think that things have got lost that you felt you argued. From the advocate's point of view, I think, if I'm honest with myself, and it's something that's obviously done much more in court, is there's much more focus on oral closing submissions. So you do a very full opening, but then you have more of an oral closing submission. So of course you give all the transcript references and everything else. But do arbitrators really benefit from 300 pages of written closing submissions, which they receive 8 weeks after the hearings happened, by which time everything, it seems to me, and when I sat, it's very difficult to keep that in your mind if you've gone off and done however many other cases in between. I don't want it to sound all criticism of tribunals, but as I predominantly do the advocate's job, that's where I see it from my clients. I think as advocates and teams, I mean, I include in that obviously international arbitration teams, solicitors firms, I think it's really important that we all look at, do those closing submissions really help? Because they cost a fortune and they take so much time up.
Everything you've said, I completely wholeheartedly agree with. And there are probably a few other things we could talk about. But the things you've mentioned there are so important, because the cost of international arbitration has really become very high now. And the consumers of arbitration, i.e. the clients, are the ones who are really suffering the detriment of that. Lawyers like us, as fine as we are, as fine as we think we are expensive. And then you've got the time that you mentioned the process takes. the cost of the arbitrators, the cost of venues, the cost of travel, and everything else. Travel, of course, coming back now. But, from your perspective, one of the things that I often think about is, and you made reference to this, arbitration can be a little bit more informal in the sense that you can do certain things you can't do in litigation. But one of the things that there isn't really a very strong focus on in arbitration is the ability to make summary decisions, in the sense that if you want to get a summary decision from a judge, you can apply for one. But in arbitration, you don't really have that ability. I wonder what your experience is, Rachel, of should arbitration tribunals, via the arbitration rules, which would have to be rewritten and other practice, should there be a better practice of getting sort of more summary determinations on points, more proactive tribunals on points, a greater case management of cases? I wonder what you think about that.
Well, again, as long as it saves money rather than adds to it, because the problem with preliminary issues, summary determination, it can just you end up having 3 or 4 hearings. So it does depend on the arbitrator or tribunal, I think, interacting with the parties as well. Because I think there are certain cases where I think it's been screaming for a preliminary issue or a summary determination, and you just can't, no one wants to do it because they're too scared of it. Now, it seems to me that if there was something that you could properly do, construction of a contract or something like that, to go back to your travel point and costs and that coming back, I, as an advocate, am a very firm believer of certainly having in-person hearings when you've got witness evidence and experts. I just don't believe it works. I think with submissions, there may be an argument. And so if you could do part of a case, perhaps remotely, if that would reduce some of the cost, that might be an answer. But I think it's very difficult. As you say, the rules would require quite a lot of thought, and what that would mean if you got a summary determination that you weren't particularly happy with, and having that as binding, because you never always feel quite so comfortable, I think, when things are done like that.
Yeah, no, I know. It's one of those things, I suppose, because we always look at these things as arbitration being a really good thing, which it clearly is, but there's always room for improvement. Now, one of the things which you are, Rachel, on any estimation, is you're a real role model for female lawyers. And you and I both know the importance, the rightful importance of diversity, equality, and inclusion in the law. We've come a long way, as I'm sure you and I would agree.
Yes.
We were very young as a pupil barrister, when you were a pupil barrister, when I was a trainee solicitor, and now as we're more senior in our respective fields. But there's still a long way to go. And I just wonder if you could share some of your thoughts as to what we can all do to improve these very important concepts in what we do, not just in the law, but more generally.
I think you've got to keep challenging yourself and keep seeing whether you've got biases anywhere. And so within your own organisations or teams, making sure that issues of diversity are to the forefront. I'm about to retire as chair of Tech Bar, but we've had a lot of focus. We set up a Black inclusion group to do us a paper and a report, and that was very, very uncomfortable reading. And it's very worrying seeing what is still going on. And so I think the professional associations, keeping it to the forefront, listening, and then more importantly, don't get a report and put it on a shelf and forget about it. Now, it might be you can't solve the problem in 2 or 3 months, but if you start to put measures in place, little steps it might be to start with, then I think you can really make a difference. And as I say, it's important to keep challenging and keep coming up with different ways of raising awareness. I think it's very important at what I call the outreach stage. So the student stage, if you like, the sort of sixth form and into university, because if you don't get someone and tell them, look, you can come to the bar or you can come to the solicitor's profession. We're not all white, male, stale, whatever the word is. There's a vibrancy about this profession. It's a great profession. Unless you tell them, you're very unlikely to ever get proper equality, because that's where decisions are made. So I see that as a very important part of it. And so, for example, in Chambers, it's a small thing. We had a 4PC Pride moot for students to come and moot, and Lady Justice Carr kind of came and agreed to judge it. But what was good is it just raised his profile and says, support Pride, and we're keen to support it. And just those sort of initiatives, which I say are very small steps, but they just keep it in everybody's forefront. And I do think outreach is important. And then within, I hope I am a mentor, and it's very nice of you to say a role model, but certainly a mentor to young barristers, be they male or female, I hasten to add, because I think we, but just because we all face different biases. And I think that's really important. I think the one thing that really irritated me as a junior female was when there was a suggestion that females required some sort of positive discrimination or quotas. And it doesn't help, actually, because if you get a job you're not right for, that's not going to help anything. But worse than that was when I took Silk and you hear someone saying, well, of course she did because she's a woman. And you think, that's really, it just sort of bursts your balloon. And so those sort of attitudes, the idea that because people are putting in place measures to make it fairer doesn't mean that actually all the women who took Silk since, well, let's say in my year in 2014 got it because there was a quota. That said, I'm not a fan of positive discrimination myself. I think you just need to make it a meritocracy. So, sorry, I think I pontificated a bit there, but I feel quite strongly about that.
I loved it. No, honestly, Rachel, I love it because I feel as passionately as you do about these concepts and these issues. And we've seen a lot of change undoubtedly over the years. There has been a lot more. I mean, look at our High Court bench. We've got Lord Justice Singh, we've got Justice Saini, we've got Justice Chowdhury, we've got a number of female judges. We've had Lady Hale heading up our Supreme Court. We've got Lady Black on the Supreme Court, Lady Arden. But there's a lot more to be done because there's a lot more people coming through the system. And I do get concerned about social mobility issues. I do get concerned about people not being, quote, sophisticated enough, close quote, when they come to interview and where there are these biases. And I think the outreach point is very important. We as a law firm do the same thing, Rachel, and so do other law firms. I saw the Pride moot that you mentioned on LinkedIn, and I was very happy to see that, actually, because, again, there are so many facets to diversity, equality, and inclusion. So, again, you weren't pontificating, saying exactly what I was thinking. So thank you for being so candid. So, now as we wrap up the podcast, I always like to sort of finish off on a more lighthearted note. And I like to ask our guests a few how can I say, fun questions?
Yeah.
So I wonder if you could share a few thoughts on that in that respect, Rachel. Have you got a favourite film or films?
Well, at the moment, my favourite film is Top Gun Maverick, which I was lucky enough to go to a private preview, which I absolutely loved. So that's obviously fresh in my mind. And then in terms of a guilty pleasure, I very much like Legally Blonde.
Oh, yes.
And it amused Lord Justice Popperwell because he was one of my referees for Silk. And he came to my Silk party and I informed him that in honour of the Legally Blonde, I had my Silk's jacket lined in a pastel pink. And he made me promise that when I was in front of him in it, I would flash him that jacket. So that's my guilty pleasure. You probably shouldn't like it, but I think it's a fun film. So.
I think that's brilliant. I can't resist just briefly coming back to you on that. Top Gun, I've not seen Top Gun Maverick yet, but I still love the original Top Gun. I just think it's a classic and it'll always be a classic for lots of reasons.
Yes.
And last week, I had the great privilege of watching Legally Blonde at the Regent's Park Open Air Theatre. And since you mentioned Legally Blonde, I couldn't resist mentioning it. So last Wednesday, we saw the production and it was a glorious evening. It was a lovely summer's evening. It was just fantastic. So I just could not resist mentioning Legally Blonde too. And how about music? Do you have any favourite singers, bands or types of music, Rachel?
Yeah, you're definitely trying to embarrass me with these questions. So here we go. Take That. I've been a fan for years. Okay. Tom Jones, because we talked earlier about my interest in cricket, but I've also got a massive interest in Welsh rugby. So Tom Jones is obviously a part of that. And then if I'm being more serious, Maria Callas and Ella Fitzgerald. So it's quite an eclectic mix. But yeah, I'm afraid I have to Take That at the top of that list, I think.
That's a brilliant, actually, that's a brilliant. I tell you, that in itself could spawn another podcast, actually. That's a superb, diverse mix of music. I can't resist asking this question: cricket or rugby?
Oh, I can't answer that question.
It's tough, isn't it? It's tough.
Yeah,
It's
I
tough.
can't. It depends on the time of year. In the winter, rugby, and in the summer.
I've got to tell you, I love both, but I'd have to say rugby union would be my number one.
Oh,
But I love both,
yeah,
and and they're both wonderful sports
yeah.
in different ways. My last question, Rachel, is this: we spoke about travel coming back a bit more, and
Mm.
happily so. I've been lucky enough to have been to the US a couple of times on business this last 5 weeks. I've been to the States twice, and thankfully, travel is coming back. Are there any places that you and your family love traveling to, or that you would love to travel back to sometime soon?
So I think the sort of sunshine holiday, Mauritius, I absolutely love.
Yes, very nice.
I'm slightly limited to where I can travel because I'm allergic to all fish and shellfish and the same. So there's some places where the cuisine is such I just can't go. Picking up on our last conversation, I've been lucky enough to watch the Lions in Australia and in New Zealand.
Amazing.
We won one and we drew the other series, so they were good series to go. And I've also watched cricket in Australia, so I'd love to get back down to Australia to watch some cricket and watch some rugby. I think it's South Africa next, is it? No, that's gone, hasn't it? Whatever the next Lions is. So I
It's Australia.
Australia. I do certainly like the sports travel. And then closer to home, I must admit, I'm someone who does love going to Paris.
Again, a fabulous range of places.
Yeah.
I tell you one thing, as we just finish up this podcast, I've not been lucky enough yet to go to a Lions tour. I really wanted to go to the one in South Africa, just gone, but obviously it wasn't possible due to COVID restrictions. But I remember the 2013 series you mentioned when our lads won 2-1, and that final test match when it was an absolute rampage at the end. And then the drawn series in New Zealand when that controversial final decision. But that's why I think Romain Poitre is the second best referee in the world, because he made that decision and the Lions therefore drew that series. So, again, I could talk to you for hours on this.
Yeah, well, I certainly would just add to the one in Sydney, which was amazing when we won that. But you've got to appreciate, as a Welsh supporter with 8 Welsh players on the ground, I've got a red shirt on, which is close enough. And when the boys won it, they played Tom Jones. It was like I'm back in Cardiff.
It had to be done. It had to be done. No, and I've got to tell you, Rachel, I think the best stadium for atmosphere in the home nations is definitely in Cardiff. I've been there in the open air and when they close the roof, and it is absolutely extraordinary. And, I long to get back there again sometime soon. So, Rachel, thank you very, very much for being such a wonderful guest. I've loved our conversation, and it's been really nice to talk to you about all these various issues. So thank you very much, and look forward to seeing you again very soon.
Well, thank you for inviting me. Thank you.
Arbitral Insights is a Reed Smith production. Our producer is Ali McCardle. For more information about Reed Smith's global international arbitration practice, email arbitralinsights@reedsmith.com. To learn about the Reed Smith Arbitration Pricing Calculator, a first-of-its-kind mobile app that forecasts the cost of arbitration around the world, search Arbitration Pricing Calculator on reedsmith.com or download for free through the Apple and Google Play app stores. You can find our podcast on Spotify, Apple, Google Play, Stitcher, reedsmith.com, and our social media accounts at Reed Smith LLP on LinkedIn, Facebook, and Twitter. This podcast is provided for educational purposes. It does not constitute legal advice and is not intended to establish an attorney-client relationship, nor is it intended to suggest or establish standards of care applicable to particular lawyers in any given situation. Prior results do not guarantee a similar outcome. Any views, opinions, or comments made by any external guest speaker are not to be attributed to Reed Smith LLP or its individual lawyers. All rights reserved.